A single question just exposed the biggest problem with one of Trump's judicial picks. Senator Adam Schiff asked a simple thing. Have you ever taken a case to a jury verdict? What came next wasn't just an awkward pause. It was a resume built on watching trials, not running them. This is the nominee the American Bar Association would later call not qualified, the first of this administration to earn that label. Stick around, because this exchange says a lot about who gets handed a lifetime seat on the federal bench.
Lane, I wanted to ask you about your experience trying cases. Have you ever tried a case to a verdict before a jury?
Senator, I've worked on a bench trial, and as a federal law clerk, I handled 7 trials.
I was a federal law clerk as well. I wouldn't say that I handled the trials. I think the judge handled the trials. But let me ask you about your experience with the bench trial. Were you the lead counsel in that case?
No, Senator, I was part of a small team of attorneys.
Were you the senior or associate counsel on the case?
Yes, Senator, I was an associate on the case. There were 4 attorneys on the case. I was responsible for helping prepare witnesses, helping second chair depositions. I also took a deposition myself. I cross-examined a witness at trial, and I was responsible for all the pretrial and post-trial briefing, findings of facts, conclusions of law.
And of the 4 attorneys, how many were more senior to you on that team?
Senator, I believe 2. There were several people who came in to assist, but again, my responsibilities, I was the primary drafter for all the briefing.
No, I heard that. I just want to understand. So your trial experience consists of being the second or third senior lawyer on a bench trial.
The exchange between Senator Adam Schiff and a Trump judicial nominee centered on a basic question of courtroom experience, and it carries significance far beyond one confirmation hearing. Schiff pressed the nominee on whether he had ever actually taken a case through a jury trial and reached a verdict.
Senator, yes, it was a week-long trial involving complicated constitutional issues, and my role, again, was I helped draft and prepare all the briefing.
But you've never done jury selection, never done voir dire, for example?
When I was a law clerk, Senator, 5 of the trials before the judge who I clerked for were jury trials, and so I had the opportunity.
And I was a law clerk. It was a great experience, but I didn't pick the jury when I was a law clerk. I didn't question the jurors. I didn't seek to use a peremptory or other challenge for cause for a juror. That's really not the role of a law clerk. You observe it, but you don't do it yourself. And so have you, apart from the bench trial, have you cross-examined witnesses in any kind of other jury trial or any jury trial?
Senator, in that case, I cross-examined a lay witness. I also deposed an expert, and I was...
Never before a jury. Have you ever filed or argued a motion to eliminate?
Yes, Senator. I've, in that matter, handled several motions in limine, as well as in other matters, particularly at preliminary injunction stage. Some of the litigation I've been involved with has had extensive evidentiary records at the preliminary injunction stage. So I've filed and handled several motions and many motions in limine, Senator.
Adam Schiff's questioning put a very specific weakness, or at least a potential concern, under the microscope. Hands-on trial experience. Rather than focusing only on credentials or legal theory, Schiff asked the Trump judicial nominee directly about experience taking a case all the way to a jury verdict.
Many motions to eliminate in that one bench trial?
Yes, Senator. In that one bench trial, I handled several motions in limine, but I've also handled motions in limine in other litigation, again, more at the preliminary injunction stage, seeking to clear the establish a clear record going into a preliminary injunction hearing where there may be live witnesses, evidentiary issues, kind of at that initial stage.
Okay, thank you. I'm not trying to denigrate your experience as a law clerk. I think it's a great experience, and I highly encourage those graduating from law school to pursue clerkships. But having tried cases as an assistant U.S. attorney, it's not the same thing. To observe them and to do them yourself, I'm sure you would agree. But thank you, I appreciate it, and Mr. Chairman, I yield back.
Thank you. Before
Senator Adam Schiff's exchange with Kathleen Lane, President Trump's nominee for a lifetime seat on the U.S. District Court for the District of Montana, captures something that goes well beyond a single awkward moment in a confirmation hearing. Schiff, a former federal prosecutor himself, asked Lane directly whether she had ever tried a case to a verdict before a jury, and her answer revealed a resume built almost entirely around observation rather than execution. She pointed to a single 4-day bench trial where she served as a junior member of a 4-lawyer team, one deposition she conducted herself, one cross-examination of a lay witness, and a stint as a law clerk where she watched other attorneys and judges run trials. When she tried to count her clerkship experience as trial experience, Schiff pushed back sharply, noting that observing a trial and running one are fundamentally different skills, and that a law clerk's job is to watch the judge work, not to do the judge's job themselves. What makes this moment worth dwelling on is the sheer weight of what's being decided. A federal district judgeship is not a temporary posting or an advisory role. It is a lifetime appointment, with the authority to preside over jury selection, rule on evidentiary objections in real time, manage a courtroom under pressure, and issue judgments that can reshape people's lives, businesses, and freedom. District courts are, by design, trial courts, which means the skill Schiff was probing for isn't a nice-to-have, it's the core job description. Lane's own Senate questionnaire response confirmed the sparse numbers Schiff was working from. One case taken to judgment as associate counsel in a bench trial, no jury trials as lead counsel, no voir dire conducted personally, no peremptory strikes exercised, no experience picking or questioning a jury from the attorney's chair. It's also worth setting this exchange against the broader confirmation record, because the American Bar Association's Standing Committee on the Federal Judiciary later rated Lane not qualified, making her the first nominee in the current administration to receive that designation. The ABA's own reasoning echoed almost exactly the ground Schiff had covered in the hearing. Fewer than 8 years in trial courts, fewer than 7 years as a litigator against a recommended baseline of 12, and no case ever tried as lead counsel in either a civil or criminal matter. That's not a partisan reading of her career. It's a professional peer review body applying the same standard it applies to every nominee, regardless of party, and reaching a conclusion that lines up with the specific gaps Schiff surfaced under oath. None of this is to say credentials on paper don't matter. And Lane's supporters aren't wrong that her academic record and range of postings, from a Federalist Society-aligned law school to 2 federal clerkships to a state solicitor general's office, are real accomplishments. But there's a meaningful difference between a strong legal resume and courtroom-tested judgment. And the entire point of a confirmation hearing is to force that distinction into the open, rather than let it hide behind titles like senior counsel or deputy solicitor general. Schiff's questioning did exactly what that process is supposed to do. It took vague, favorable-sounding phrases and reduced them to countable, verifiable facts. My own take is that this exchange should matter to anyone who cares about how the federal bench actually functions, not just to people following partisan judicial fights. Trial experience isn't a credentialing formality. It's the difference between a judge who can spot a bad objection in real time and one who's learning courtroom mechanics for the first time from the bench. In cases where real people's outcomes are on the line, a nominee can be personable, well-connected, and academically accomplished and still be underprepared for a job that is, at its core, about running trials. Schiff didn't ambush Lane with a trick question. He asked the single most basic question you'd ask of any trial court nominee, and the answer he got, later validated by the ABA's independent review, should be a serious concern for senators on both sides of the aisle, not just the ones who happen to ask it.